I'm Matt Gelka in Washington, where another case in front of Supreme Court justices involved the potential expansion of presidential power. President Trump tried firing Rebecca Slaughter, a Democratic member of the Independent Federal Trade Commission, back in March as he sought to reshape the government. Lower courts blocked the firing, but an emergency order from the Supreme Court allowed it to go through. The High Court now decides if Trump was within his rights to do it or if the move violated the separation of powers. The ruling could greatly expand his and future presidents' executive power over independent agencies. The court's liberal justices questioned giving more power to a sitting president.
I don't understand why it is that the thought that the president gets to control everything can outweigh Congress's clear authority and duty to protect the people in this way.
A 90-year-old precedent known as Humphrey's executor stands in the way of letting the president fire independent agency heads on a whim.
Hey friends, welcome. Adam is here, so let's get started. The DC Circuit Court of Appeals just issued a unanimous ruling. No dissents, no concurring opinions, complete rejection, declaring Trump cannot fire independent agency officials at will. Every judge agreed. The court ordered immediate reinstatement of everyone he terminated, including Federal Reserve Chair Lisa Cook, and explicitly threatened Trump with personal contempt if he refuses to comply.
Welcome to the News Hour. The Supreme Court heard arguments today in a legal case that could vastly expand presidential powers. At stake are 90 years of precedent that have kept presidents from being able to remove members of independent government agencies. The case looks at whether President Trump acted legally in firing Rebecca Slaughter, a Democratic member of the bipartisan Federal Trade Commission, saying her service was inconsistent with Trump administration priorities. Slaughter sued, arguing that commissioners can only be fired for inefficiency, neglect of duty, or malfeasance. Today, Trump administration lawyers argued that gives agencies too much power.
It continues to tempt Congress to erect at the heart of our government a headless fourth branch, insulated from political accountability and democratic control.
The ruling is built on a 1935 Supreme Court precedent that has stood nearly unchallenged for 90 years. Independent agencies exist precisely to make decisions based on law and expertise, not presidential preference. Trump spent his entire presidency treating that principle as an obstacle. The court just told him it's the law. Trump has never accepted this limitation. He views any constraint on his removal power as an unconstitutional infringement on Article II authority.
But liberal justices warned about the impact this could have on the balance of power.
You're asking us to destroy the structure of government and to take away from Congress its ability to protect its idea that the government is better structured with some agencies that are independent.
Joining me now to discuss today's arguments is the NewsHour's Supreme Court analyst, Amy Howe. She's co-founder of SCOTUS blog. Good to see you, Amy.
Good to see you, too.
So let's set the table here. Rebecca Slaughter was actually first appointed by President Trump in 2018, reappointed by President Biden, fired by Trump in March. The Trump administration called the legal precedent that usually protects people like her from being removed a decaying husk. What's behind that legal precedent that's protected people like Slaughter?
So this is a decision that dates back to 1935 and, in fact, involves very similar facts. FDR wanted to fire a commissioner of the Federal Trade Commission in no small part to put his own people in the job. The commissioner resisted. He eventually was fired, went to court. And the Supreme Court in that case upheld the same removal statute that is at the center of this case. It said Congress enacted these removal statutes precisely because it wants agencies like the FTC to be independent. And it isn't infringing on FDR executive power because the agency doesn't exercise substantial executive power.
His legal team has advanced arguments claiming that the president must possess absolute control over every person exercising executive power, that independent agencies are constitutional anomalies that should be eliminated, that Humphrey's executor was wrongly decided and should be overturned. And while his lawyers made these arguments in court filings, Trump acted on them in the real world. He fired Lisa Cook from the Federal Reserve because she refused to support the monetary policy he demanded. He fired FBI officials who had worked on investigations touching his associates.
Within days of taking office, President Trump fired more than 17 inspectors general across the federal government. It's already resulted in a lawsuit challenging the legality of the dismissals and continued protests outside federal agency buildings, like outside the Department of Health and Human Services today. Our White House correspondent, Laura Barone-Lopez, has more.
Jeff, 8 of those fired inspectors general are now suing the Trump administration, seeking to be reinstated to their positions. These independent government watchdogs are a key check on waste, fraud, and abuse.
He fired independent agency heads across the government who enforced laws he disliked or regulated industries he favored or simply failed to demonstrate the absolute personal loyalty he considers the only legitimate qualification for government service. Lower courts began blocking these firings almost immediately. Judges looked at the Humphreys executor precedent, looked at the statutory protections Congress had enacted for independent agency officials, looked at Trump's stated reasons for the terminations, and concluded that the firings were plainly illegal. They ordered reinstatement. They issued injunctions. They made clear that the president cannot simply wish away 90 years of settled law because he finds it inconvenient. Trump appealed. He asked for emergency stays of those lower court orders. He argued that he needed time to litigate, that maintaining the status quo during appeals was standard practice, that the courts should let him keep his preferred officials in place while the legal process unfolded. The DC Circuit said no, unanimously. Every judge on the panel agreed that Trump's position was so clearly unlawful that he was not entitled to the ordinary courtesy of a stay pending appeal. The lower court orders stand. Compliance must be immediate. The fired officials must be reinstated by the end of the day. The court's opinion cited Trump's pattern of defying judicial orders as a specific reason for denying the stay. This is crucial. Courts do not typically reference a litigant's behavior in other cases when deciding procedural motions. But the DC Circuit made explicit what every observer already knows. Trump has been systematically testing the judiciary's willingness to enforce its own authority. His DOJ officials like Patel and Bondi have faced contempt proceedings for obstruction. His lawyers have been threatened with arrest for failing to comply with discovery obligations. His administration has repeatedly missed deadlines, ignored orders, and treated judicial commands as the opening bid in a negotiation rather than binding legal obligations. The court essentially said, "We see what you are doing. We are not playing this game anymore. And if you try to defy this order the way you have defied others, the consequences will fall on you personally." Personal contempt. Those two words represent a threat that no previous court has directed at a sitting president with this level of specificity. The court did not threaten to hold the administration in contempt, did not threaten to sanction Trump's lawyers or staff or agency heads. It threatened to hold Donald Trump personally in contempt of court. Personal contempt means personal fines that cannot be paid from campaign accounts or political action committees. Personal contempt means the theoretical possibility, however remote, of coercive incarceration. Personal contempt means that the judiciary has identified the president himself, not the office he holds, as the party responsible for compliance and the party who will suffer consequences for defiance. The immunity that Trump has claimed as a shield against accountability does not protect him from contempt sanctions imposed by federal courts enforcing their own orders. Lisa Cook's reinstatement deserves particular attention because it illustrates exactly what is at stake in this struggle over presidential removal power. Cook serves as a governor of the Federal Reserve, an institution whose independence from political pressure is absolutely essential to the functioning of the global economy. The Fed sets interest rates. It controls the money supply. It makes decisions that affect every American's mortgage and credit card and retirement account. Those decisions must be based on economic data and professional judgment, not on what the president wants for his re-election prospects or his approval ratings. Trump wanted rate cuts. He wanted loose monetary policy to stimulate the economy before voters went to the polls. Cook analyzed the inflation data, considered the employment figures, examined the economic indicators, and concluded that rate cuts were not appropriate. So Trump fired her. He claimed she was incompetent. He claimed Article 2 gave him absolute removal authority. He claimed Humphrey's executor was irrelevant or unconstitutional or both. The Federal Reserve screamed, not metaphorically. The institution understood that if Trump could fire Fed governors for policy disagreements, then Fed independence was dead. Every future governor would know that their job security depended on pleasing the president rather than following the data. Monetary policy would become just another tool of political manipulation, with predictable consequences for inflation and economic stability. The courts agreed with the Fed. They said Trump cannot fire Lisa Cook because he dislikes her votes. She has a fixed term established by statute. She can only be removed for cause, and policy disagreement is not cause. The lower courts ordered her reinstated. The DC Circuit affirmed those orders and demanded immediate compliance. Cook gets her position back, and Trump must accept that he cannot control the Federal Reserve by purging its leadership. The FBI officials Trump fired represent another dimension of the same problem. These are career law enforcement professionals who worked on investigations that touched Trump or his associates. They did their jobs. They followed the evidence. They pursued leads wherever they led. And when those leads pointed toward people connected to the president, they did not look the other way, or bury the investigation, or pretend they had not seen what they had seen. Trump fired them. He called them part of the deep state. He claimed they were politically motivated. He insisted he had the right to remove anyone in the executive branch who failed to demonstrate sufficient loyalty. The courts disagreed. The statutory protections for career officials exist precisely to prevent presidents from turning federal law enforcement into a personal protection service. The fired FBI officials must be reinstated. They must be allowed to continue their work. Trump must accept that the FBI is not his personal investigative agency. The independent agency heads across the government face the same reality. The FTC enforces consumer protection laws that apply to Trump's business empire. The SEC regulates securities markets where Trump's companies operate. The NLRB oversees labor relations that affect Trump's properties. Each of these agencies has leaders with statutory protection from at-will removal. Each of those leaders was selected through the constitutional process of nomination and confirmation, not through presidential whim. Each of them serves terms that extend beyond any single administration by design. Trump tried to fire them anyway. The courts said no. They must be reinstated. They must be allowed to do their jobs. Trump must work with independent officials he cannot control. The broader judicial context makes this ruling even more devastating. This is not the first time courts have blocked Trump's executive overreach. It is not the 10th time. Federal courts have struck down more than 20 of Trump's executive actions since he took office. The Supreme Court invalidated his tariff scheme and ordered billions in refunds. Lower courts blocked his birthright citizenship order. 29 federal judges have stripped away claims of immunity and executive privilege that Trump's legal team constructed to shield him from accountability. Judge Boasberg explicitly signaled that removal mechanisms were available if Trump continued to test constitutional boundaries. The DC Circuit ruling is not an isolated event. It is the culmination of months of systematic judicial pushback against a president who believes he operates above the law. The unanimous nature of the ruling carries special significance in an era when judicial decisions on politically charged issues often split along ideological lines. When a panel that includes judges appointed by presidents of both parties reaches complete agreement, it signals that the legal question is not close. This is not a case where reasonable jurists might disagree. This is not a situation where the law is unclear or the precedents point in different directions. Humphrey's executor has been settled law for 90 years. Congress has clear authority to create independent agencies with removal protections. Trump's position is not a plausible interpretation of the Constitution. It is a direct challenge to the constitutional order that every judge on the panel, regardless of who appointed them, rejected. The same-day compliance requirement represents an extraordinary departure from normal judicial practice. Courts typically grant reasonable time for compliance with their orders. Days or weeks to handle the logistics of reinstatement, to process paperwork, to notify affected personnel. The DC Circuit said, "End of day today." That urgency reflects the court's assessment of Trump's good faith. They do not trust him to comply if given time to delay. They do not believe he will use additional time to facilitate orderly reinstatement. They expect him to use any available time to scheme, to find new justifications for non-compliance, to create procedural obstacles, to do anything except actually follow the court's order. So they eliminated the time. Comply now, not tomorrow, not next week. Today. By the end of business. The court is treating Trump the way courts treat litigants who have demonstrated bad faith. That is a damning institutional judgment. Trump's response has been entirely predictable and entirely ineffective. He posted on Truth Social calling the ruling a deep state coup. He claimed unelected judges were stripping him of constitutional powers. He suggested he would not comply, that he would keep fighting, that he would find some way around the court's order. But his rhetoric runs directly into the brick wall of judicial authority. The court anticipated his defiance. That is why they included the personal contempt threat. That is why they demanded same-day compliance. That is why they cited his pattern of defying orders in the opinion itself. They are not surprised by his reaction. They planned for it. And they have made clear that if he follows through on his threats, the consequences will be imposed on him personally. The impeachment implications are immediate and severe. Defying a federal court order is textbook impeachable conduct. The House Judiciary Committee has already heard whistleblower testimony about Trump ordering obstruction of the Epstein investigation. They are already drafting articles of impeachment. Trump defying this court order would provide another article, another count, another constitutional basis for removal. House Democrats do not need to prove a complicated conspiracy or establish criminal intent. They simply need to point to the court order, point to Trump's public statements vowing defiance, and say this president is openly refusing to comply with binding legal commands from the judicial branch. That is exactly the kind of conduct the impeachment power was designed to address. A president who will not follow court orders cannot remain in office consistent with the constitutional structure. The political consequences extend beyond impeachment. Every day Trump spends defying courts is another day Democrats can campaign on the rule of law versus lawless executive power. Every court ruling blocking his actions is evidence for the argument that Trump is not merely wrong on policy, but fundamentally incompatible with constitutional governance. The midterm messaging writes itself. Trump tried to purge independent agencies. Courts stopped him. Elect more Democrats to hold him accountable through Congress because the courts cannot do it alone. That is powerful, especially after the Epstein obstruction testimony. Democrats can paint a coherent picture of a president who believes he is above the law and whose own actions prove it. The erosion of Trump's base support follows a predictable trajectory. His supporters want a strong president who fights the system and wins. They want someone who shakes up Washington and delivers results. But when courts keep blocking him, keep stripping his power, keep forcing him to reinstate officials he fired, he starts to look weak, not strong, not effective, not capable of delivering the disruption he promised. The base does not abandon him all at once, but gradually, incrementally, the enthusiasm fades. People who voted for Trump because they believed he would break the system start wondering what the point is if the system keeps breaking him instead. That erosion matters for impeachment because senators who might otherwise fear primary challenges become less concerned about Trump's political strength. If his base is shrinking, the cost of crossing him shrinks too. The Fed independence restoration is particularly significant for the broader economy. Financial markets rely on the assumption that monetary policy will be set by independent experts following economic data rather than by politicians following electoral incentives. Trump's firing of Lisa Cook threatened that assumption. If presidents can fire Fed governors for policy disagreements, then Fed independence is a fiction. Markets would have to price in the risk that monetary policy could shift dramatically based on political rather than economic considerations. The court's reinstatement order restores the credible commitment that Congress created when it established the Fed's structure. Monetary policy will continue to be made by governors with fixed terms and for-cause removal protection. Trump cannot manipulate interest rates by firing people who refuse to cut them. The FBI reinstatements matter for ongoing investigations. The officials Trump fired were working on cases that touch his associates and potentially the president himself. Removing them and replacing them with loyalists would have allowed Trump to control the direction of those investigations, to slow them down, to redirect resources, to ensure that certain leads were never pursued. The court's order restores the career professionals to their positions. The investigations will continue under the same leadership that was pursuing them before Trump's intervention. The independence of federal law enforcement, battered and bruised, survives another assault. The independent agency reinstatements matter for regulatory enforcement across the entire government. The FTC will continue investigating consumer protection issues without fear that the president will fire commissioners who pursue cases against his businesses. The SEC will continue securities enforcement without concern that the president will remove officials who investigate his associates. The NLRB will continue labor relations oversight without pressure to favor Trump's properties. Each reinstated official represents a node of resistance to presidential control, a point where the law rather than loyalty determines outcomes. That is precisely what Congress intended when it created these agencies with these protections. That is precisely what the courts have now enforced. The personal contempt threat hanging over Trump creates a dilemma with no good resolution. If he complies with the court order, he admits that his conception of presidential power was wrong. He acknowledges that courts can force him to reinstate officials he fired. He demonstrates that his threats to defy judicial authority were empty. His supporters see weakness. His opponents see vindication. His power shrinks. If he defies the court order, he invites contempt sanctions, fines that accumulate daily, escalating judicial responses, potential arrest warrants for contempt that would create a constitutional crisis without modern precedent. And each act of defiance becomes another article of impeachment, another count in the case for removal. There is no path that preserves his power. There is no option that allows him to emerge stronger. Every choice leads to diminished authority. The cascading effect of multiple court losses compounds the damage. When the Supreme Court struck down his tariffs, that was one branch of his executive power strategy eliminated. When lower courts blocked his birthright citizenship order, that was another. When judges stripped his immunity claims, that was another. Now the DC Circuit has eliminated his ability to purge independent agencies. Each ruling removes another tool from the presidential toolkit. Each decision narrows the scope of unilateral action. Each judicial rebuke reinforces the message that Trump's conception of executive power is not merely controversial, but constitutionally invalid. The accumulation matters because it creates a pattern that even his supporters cannot ignore. This is not one rogue judge or one activist court. This is the entire federal judiciary, across ideological lines and geographic regions, consistently rejecting Trump's claims of unlimited presidential authority. The 90 years of precedent that Trump tried to overturn represents the accumulated wisdom of judicial interpretation across administrations of both parties. Humphrey's executor was decided during the New Deal, when the Supreme Court was wrestling with fundamental questions about the scope of federal power and the structure of administrative governance. The court concluded that Congress could create independent agencies with removal protections without violating Article 2. That holding has been reaffirmed repeatedly. It has been applied to new agencies created by subsequent Congresses. It has become part of the constitutional fabric. Trump's argument that it was wrongly decided and should be overturned is not impossible. The Supreme Court can overrule its own precedents, but it requires 5 votes, and the lower courts are bound by existing precedent until the Supreme Court says otherwise. The DC Circuit was not free to ignore Humphrey's executor just because Trump's lawyers argued it was incorrect. They were bound to apply it, and applying it meant ruling against Trump. The same-day compliance order reveals something important about how the judiciary views this president. Courts do not issue same-day compliance orders to litigants they trust. They issue them to litigants who have demonstrated that they will exploit any available delay, who will use additional time to evade rather than comply, who treat procedural generosity as an opportunity for obstruction. The DC Circuit has been watching Trump's behavior across multiple cases. They have seen the pattern. They have concluded that he is not a good faith litigant entitled to ordinary courtesies. He is a president who tests every limit, pushes every boundary, and complies only when forced. So they forced him. End of day today. No extensions, no excuses. Reinstate the officials now. The connection to the 29-judge immunity ruling adds another layer of significance. That ruling established that Trump could be held personally accountable for conduct that would otherwise be shielded by various immunity doctrines. It opened the door to personal liability in ways that previous presidents never faced. The DC Circuit's personal contempt threat walks through that open door. If Trump can be held personally liable for his official acts, he can certainly be held personally liable for defying court orders. The immunity ruling made this threat credible. Before that ruling, Trump might have argued that contempt sanctions against a sitting president were constitutionally problematic. After that ruling, the argument collapses. Personal accountability extends to compliance with judicial orders. The whistleblower testimony about Epstein obstruction provides the political context that makes this court order particularly dangerous for Trump. The House is already investigating serious misconduct. Impeachment articles are already being drafted. Trump's defiance of this court order would not occur in a vacuum. It would occur in the middle of an active impeachment inquiry focused on obstruction of justice. Defying a court order while under investigation for obstructing another investigation is not a good look. It reinforces the narrative that Trump believes he is above the law. It provides additional evidence of the same pattern of behavior that the impeachment inquiry is examining. It makes it harder for Republican senators to argue that removal is unnecessary, because Trump has learned his lesson and will respect legal boundaries going forward. Every act of defiance proves he has learned nothing and will respect nothing. The agency revolts that this ruling enables represent a fundamental shift in Trump's governing capacity. Before the ruling, agency officials who resisted Trump's directives could be fired and replaced with loyalists. After the ruling, many of those officials have job protection. They can resist without fear of termination. They can enforce laws Trump dislikes, investigate matters Trump wants buried, and make decisions based on professional judgment rather than presidential preference. Trump can issue orders, but if the people responsible for implementing those orders refuse to comply and he cannot fire them, the orders are meaningless. The presidency becomes a bully pulpit rather than a command post. That is a massive reduction in actual power, regardless of what the formal title says. The midterm implications for Democrats are substantial. They can run on a simple message. Trump tried to turn the government into his personal operation. The courts stopped him. Now Congress needs to finish the job through oversight and, if necessary, impeachment. That message resonates with independent voters who may not love Democratic policies, but who value the rule of law and constitutional structure. It resonates with suburban voters who have been drifting away from Trump and need a permission structure to vote for Democrats. It resonates with everyone who believes that presidents should operate within legal limits regardless of party. The court rulings provide the factual foundation for that message. Democrats do not need to make partisan arguments. They simply need to describe what courts have already found. The base fracture that follows from perceived weakness is perhaps the most dangerous long-term consequence for Trump. His political movement was built on the promise of strength, on the image of a leader who could not be stopped by the usual constraints, who would break through the barriers that had contained previous politicians. But courts are stopping him, repeatedly, decisively, publicly. Each blocked executive order, each reinstated official, each judicial rebuke chips away at the perception of invincibility. Supporters who signed up for a bulldozer are watching a president who keeps hitting walls he cannot break through. Some will rationalize, some will blame the courts rather than Trump, but some will quietly conclude that the product does not match the advertising, that the strong man they thought they were getting is actually just a man who keeps losing. The contempt trap is particularly elegant because it forces Trump to choose between two versions of weakness. If he complies, he admits the courts can control him. If he defies, he invites sanctions that demonstrate he cannot protect himself from consequences. Either way, he looks less powerful than he claims to be. Either way, his supporters see a president who is not actually in charge. Either way, the myth of unlimited Trump power collides with the reality of constitutional constraints. The trap is set. The only question is which horn of the dilemma Trump will impale himself upon. The broader historical significance of this moment will become clearer with time. Future presidents will operate in the shadow of these rulings. They will know that Humphrey's executor remains good law, that independent agencies have genuine protection from political purges, that courts will enforce those protections even against determined presidential resistance. They will know that personal contempt is a real threat for presidents who defy judicial orders. They will know that the DC Circuit, and by extension the entire federal judiciary, will not tolerate systematic noncompliance. These precedents will constrain every future administration regardless of party. That is how constitutional law develops, through specific cases that establish general principles. Trump's losses are becoming the foundation for limits on all presidents. The immediate future holds only difficult choices for Trump: comply and watch his power shrink, defy and watch the consequences mount, resign and admit total defeat. There is no fourth option. There is no clever maneuver that allows him to maintain control while appearing to follow the law. The courts have closed off every escape route. The order is clear. The deadline is today. The threat is personal. Trump must decide whether to accept the limits on his power or test whether the judiciary is willing to enforce those limits against a sitting president. Either choice leads to the same destination: a presidency diminished, constrained, and ultimately defeated by the constitutional structure it tried to overthrow. The screaming on Truth Social is just the soundtrack to that defeat. The ruling itself is the reality.